Hello guys and welcome to LawPutra's YouTube channel. Today we will discuss about the difference between pleader and Mukhtar. I am Jagannath Kulkarni and I welcome you all to this discussion. Though today pleader and Mukhtar are not the terms that we hear day-to-day life, but let us discuss about the history of the legal profession in India. Legal profession in India can be traced back to the year 1672 when the Governor Augier established the first British court in Bombay. We must know that the law is the set of rules and regulations governing a society. Admission of attorneys was in the hands of Governor in Council and not with the court. So no legal practitioners prior to establishment of mayor courts in 1726 in Madras and Calcutta. Mayor courts, they were established in three presidency towns. They were like the crown courts with right of first appeal to governor in council, right of second appeal to privy council. So this was the status, or we can say the history of the courts. Then in 1791, the judges felt for the first time that there is a need for experience and a role of attorney to protect the rights of client. And they upheld in each of mayor courts this position, in spite of opposition from council members or governor. Also, right to dismiss attorney who may be found guilty of misconduct, and the first such dismissal was in the case of Attorney Jones. In 1774, Supreme Court of Judicature established by Royal Charter. Why? Because dissatisfaction with weakness of Court of Mayor. In 1801, similar Supreme Courts established in Madras, 1823 in Bombay. In 1774, with the opening of Supreme Court in Calcutta, as we seen earlier, first barristers appeared in courts and they worked as advocates because attorneys gave up the pleading and they worked as solicitors. So two grades of legal practice at that time. Gradually it became distinct and separate as in England. In 1778 in Madras, first barrister appeared whose name was Benjamin Sullivan. Then establishment of Supreme Court brought recognition, wealth and prestige to this legal profession. Charters of court stipulated Chief Justice and 3 Pusne judges by English barristers of at least 5 years standing. So this experience was counted at that time also. Legal practitioner. Who can be the legal practitioner? It is defined as legal practitioner means advocate or vakil of any high court, pleader, Mukhtar, then or revenue agent. So this can be the legal practitioner and this has been defined in clause 1 of subsection 1 of section 2 of Advocates Act 1961. Now the difference between today's our discussion point is difference between pleader and Mukhtar. So who is the pleader? Pleader is either the law graduate who did not pass additional qualification, possess additional qualification for enrollment as Vakil of High Court. Also, non-law graduate who could pass pleadership examination held by High Court. These people can act as the pleader. Mukhtar, after passing entrance exam, which was corresponding to matriculation exam of later times, and then also passed Mukhtarship examination held by High Court, they were Mukhtars. Pleader were the practitioners in district courts and subordinate courts, but Mukhtars were typically practitioners in subordinate courts, mainly confined to acting and pleading in criminal courts in Mufussil. Those were the Mukhtars. Pleaders had entry into High Court only after gaining prescribed experience of certain number of years. Mukhtar, they were not permitted to plead not in subordinate civil court, only criminal courts in Mofussil. Now, pleader, as we see, they were similar to Mukhtars. They were non-licensed legal practitioners of both criminal courts and revenue courts. They were regarded as superior to Mukhtars, pleaders. They received the legal status by the Pleaders, Mukhtars and Revenue Agents Act in 1865 and brought under control of court, which framed rules regarding their qualification, disqualification, admission, enrollment. Legal Practitioners Act 1897 repealed earlier act. This was the Pleaders Act, and it specifies the 6 classes of legal professionals in those days. Pleader, High Court which authorized to frame rules regarding qualification, they framed rules and only 2 kinds of people were eligible to be enrolled as advocates. As we have already seen, law graduates who could not get enrolled as vakils because of lack of additional qualifications, and not law graduates who had passed pleaders exam which was conducted by High Court. They could practice only before subordinate courts, not high courts, and they could be suspended on similar grounds of that of Mukhtar. All India Bar Committee in 1951, constituted under chairmanship of S.R. Das, they said only one class of legal practitioners, that is advocates, should continue. Law Commission in its 14th report supported this recommendation. Pleaders abolished. In case of Mukhtar, they are the legal professionals. They were the legal professionals who practices in typically criminal courts, also as revenue agents in revenue offices as well, but they were Mukhtars only. They had no license to practice, and sometimes they acted as solicitors for pleaders as well, thereby acting as a bridge between clients and pleaders. They were considered inferior to pleaders. The Pleaders, Mukhtars, Revenue Agents Act 1865 conferred legal status, brought under jurisdiction of court, authorizing high courts to frame rules regarding their qualification, admission, enrollment. Then Legal Practitioners Act replaced it. They prescribed minimum qualification and could be suspended by High Court if found guilty of fraud, improper conduct, if taking instruction from other than authorized agent, and so on. So these were their disciplinary actions. And Law Commission again in 14th report 1955 recommended that non-graduates should not be recruited as Mukhtars. So end of class of legal practitioners called Mukhtars. No more remained. Now see the legal practitioners. We can definitely segregate as two. One, prior to Advocates Act. Again during those days, British and Indian. In British we can find solicitors, we can find barristers, and we can find the advocates. Also attorneys. Indian case, vakils, pleaders and Mukhtars. And then came the Act, Advocates Act 1961, which recommended only one class of legal practitioners, that is advocates. But we have another category, that is senior advocates. After a certain number of years, High Court grants them the status, and also advocates on record. Lord Tennyson has said, mastering the lawless science of our law, that codeless myriad of precedent, that wilderness of single instances, through which a few, by wit or fortune led, may beat a pathway out to wealth and fame. This was today's discussion, difference between pleader and Mukhtar. I thank you, and today's our topic was difference between pleader and Mukhtar. Thank you.